Good morning. Are you Matthew Wadsworth?
Yes, ma'am.
And Mr. Wadsworth was previously in court and entered a plea of guilty to the second-degree felony offense of aggravated assault with a deadly weapon. There was an agreement for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections?
No, Your Honor.
Not from this one.
All right, Mr. Rojas, you may proceed.
As the prosecutor begins to detail Wadsworth's history, the list seems endless, case after case, year after year. Most of his felonies date back to 2002, but his criminal behavior never really stopped. It's a troubling picture. A man who's been in and out of prison for decades, trying to convince the court that this time will be different. Would you believe him? Or do you think the judge has already heard this story too many times?
The first page of his, I guess, rolling into this second page of his felony criminal history, most of those offenses happened in 2002. So he seems to be getting those in bunches. Those happened in 2002. He got sentenced in 2000. All in one. In January of 2002, they all happened.
Right.
Got revoked in 2003 on all of them. I think he did 60 months on all of them. Got some more in October 2002. Then after that, he goes in. Basically, he's in and out until about 2019 when he picks up some more cases. And from 2019 to this present.
Now, the defense shifts gears. Wadsworth's attorney argues that his crimes are linked to his mental health and medication. When he's on his meds, he behaves. When he's off, things spiral out of control. It's an emotional argument, one that touches on the fine line between illness and accountability. The defense is asking for probation and treatment instead of more prison time. Do you think mental illness should change how someone is punished?
We talked about this, and if the court's even going to consider probation, as pointed out in the PSI, the only way he's going to get probation is with safety to get help with his drug issues. He understands that. He recognizes that. He's willing to do that. He's hoping that you give him a chance to do that. And even as he pointed out by the probation officer in the report, he's indicated that he's tired of this lifestyle. He's tired of being in handcuffs. He realizes he needs help just to make his life better. And he tells me he's ready to make that change. And he does have some statements to make to you at the appropriate time.
Wadsworth finally speaks, trembling, nervous, and holding a handwritten note. He confesses to being a lifelong drug addict, raised by parents who were also addicts. He talks about childhood trauma, sexual abuse, and years of struggling with voices in his head. His words are heartbreaking. You can feel his pain, but also his excuses. Every bad choice seems to have a reason. He claims he only attacked his roommate because he believed his girlfriend was being held hostage, a delusion triggered by his mental illness. The courtroom falls silent as he admits, "I need help staying on my meds." Is this honesty or manipulation? What's your take?
It's a straight A's. I was sexually abused. My parents were drug addicts. I went to prison. You guys forgot something. I hope it don't hurt me, but I got to bring it up. I had a robbery in 1992. When I got out from that robbery until 2000. When you started 2002, yes, ma'am. From I stayed out of trouble again because I was on medication. It's been my whole life. It's been the pattern of my life. I'm on my medication. I'm a great guy. I'm a journeyman electrician. I'm a father. I'm a grandfather. I spend time with my kids. If I'm off of them, and the reason I got off of them and this offense happened is I was hearing voices. I thought my roommate was holding my girlfriend hostage. It says I hit him with a bat, but it was my walking cane. It wasn't a bat. And I did hit him, and I felt horrible because I found what was going on in my head. Our house burned down, dogs died, and I just kind of went crazy. But I did stop. I did tell in 2018. 19. I said I'm tired of this, and I'm gonna stay on my medications. When the house burned down, all my medications went with it. My truck, my tools, and everything. And I was just barely making it. And I honestly thought my roommate was holding my girlfriend against her will and hostage. When we started fighting, I was losing, and I, if you do give me the chance, what I need is some help staying on my meds. 'Cause I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Watts.
Judge West listens patiently, but her tone hardens. She acknowledges his sincerity but reminds him he's 51 years old. You've had opportunities, she says. At some point, you have to take responsibility for staying on your meds. It's a wake-up call. Compassion collides with accountability. The judge refuses to let mental health excuses outweigh public safety.
Even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think.
Then, the courtroom gasps. The judge begins listing his criminal history, and it's staggering. 39 misdemeanors. Archive felonies. One more pending. She calls it the worst criminal history I've seen. Even the defense attorney can't deny it. This time, the judge might be out of patience. At what point do you stop giving chances?
21 felony convictions. 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And out of and in addition to the 21 and the one pending, you have 16 others that were dismissed because of plea agreements and things like that. So that's 38 felonies. The last, and I get a lot of this was from '02, and a lot of it was in the same big scenario.
19 of them was in one.
But it didn't stop then. You were put back on probation in 2017. So not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith.
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's pending. Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that.
The prosecutor finally steps in, urging the judge to impose the full 8-tier sentence. He argues that probation doesn't work for Wadsworth, and that his excuses about the bat being just a walking cane show he's still dodging. Accountability. The tension peaks. Wadsworth tries to interrupt, but the judge silences him. I let you talk. Don't speak over anyone else. The courtroom knows what's coming next.
Hit him with the cane.
Hold on, don't speak over. I let you talk, so don't talk over anyone else, please.
I believe probation is absolutely right, that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence. TDC.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. There's help in prison for you with medication. It's going to be up to you when you get out to either change your life if you really want to or not, and you'll have to do that on your own. All right, good luck to you, sir. You can go back with the bailiff.